Hello guys, Svetlana Shlapak, the founder of ukvisaSuccess.com is here. Today is going to be an exciting video. I am going to show you what exactly happens with your application when you submit it, provided you are an extended family member and you submit your EEA family permit application to join your loved ones here in the UK. So there is a certain process which the Home Office follows when they receive your application, and in today's video I'll show you exactly what this process is. So let us begin.
Guys, but before I start this video, I wanted you to know that in response to many inquiries which I get from the extended family members, I decided to create a mini video series for extended family members where I explain the rules and the rights of extended family members. I've also created the online course where I guide you step by step on how to make these types of applications. You can find out more about the online course and how to get access to it if you go to ukvisaSuccess.com/EFM, which stands for Extended Family Members Access. That's ukvisaSuccess.com, EFM Access. Today we are going to concentrate on how the Home Office considers the applications, but if you'd like to know more about various rights of extended family members, you're very welcome to explore my YouTube channel and the playlist for extended family members, where you'll find all the videos devoted to this topic. Okay, so let us consider what the Home Office does when they receive applications from extended family members. First of all, you need to understand that the Home Office is not there to refuse your application. They're there to ensure that you comply with the rules and you meet the specific rules. And they have a very specific formula which they follow every single time when they receive the applications from extended family members. And in this video, I'll explain what this formula is, or process rather. The process consists of 4 stages. The first one, they consider the status of the EE national sponsor, and then they check that the EE national and the extended family members are related to each other in a way which is permitted by law, and also they check if the extended family member meets the qualifying conditions, and finally they explore the surrounding circumstances of the case. So let's have a look at stage number 1, where they consider the status of the EE national sponsor. Okay, so what they do when they explore the status of the EE national, first of all, they ensure that the person, the EE national, is either in the UK and he is a qualified person, or the person is outside the UK and they have intention of traveling to the UK. How can you prove your intention to travel to the UK? Very simply by stating what you've arranged on your arrival in the UK. For example, where you intend to live, where you intend to work, and so on and so forth. So if you have made some arrangements, this is going to be your proof of the actions in the UK. However, if you're already in the UK, you need to prove that you are a qualified person. The EE national is a qualified person. And how can you do this? Well, a qualified person is someone who is either a worker, a self-employed person, self-sufficient, or a job seeker. Okay, so let us begin with the job seekers. They can only look for a work for no more than 91 days. And how can you prove that you are a job seeker? If you're registered with a Job Center Plus, you can get a letter from them to confirm the same. Or if you're looking for work and you're making inquiries, then you need to send copies of this. Anything really to confirm that you are actively looking for a job. With regards to self-sufficient, you have to be aware that your self-sufficiency status will only be accepted if you have a comprehensive sickness insurance. Who can be a self-sufficient person? Anyone really who can support themselves without recourse to public funds. So let's say we have an EE national spouse who resides in the UK together with their visa national husband who works on a full-time basis and who supports the EE national. And the EE national wants to invite her sister on the basis of them residing together in their country of origin before the spouse came to the UK. Will this be accepted? Well, yes, if the person, the EE national who's not working but who is relying on the support of her husband, can can provide a copy of the comprehensive sickness insurance. With regards to self-employed people, this is a really straightforward matter of fact question. So if the person is registered with HMRC, then they will be recognized as self-employed person. And if they're a worker, their employment will need to be genuine and not marginal. So this means that they will need to work sufficient number of hours in order to meet the definition of a worker. And all they need to do when submitting the application, they will need to prove that they are from one of the EU national country and that they are a qualified person. Okay, that was the first stage. Now let us have a look at the second stage of the consideration process. And this is where the Home Office considers the relationship of the extended family member and the e-national. So all, from my experience, which you need to do is to provide them with the birth certificates and the marriage certificates where this is relevant. So normally with the help of the birth certificate or the marriage certificate, you would be able to prove the relationship between you and the e-national person who is a qualified person and who resides in the UK. If the birth certificates or the marriage certificates are not in English language, you would need to get a certified translation of these documents in order for them to be accepted by the Home Office. So that was our stage number 2 of the consideration process. And then we have stage number 3, which is called the qualifying conditions stage. And this is where the Home Office looks at the qualifying conditions and checks if the extended family member meets them. If you watched my previous videos from these extended family members videos, you'll find out that there are generally 4 categories of extended family members. So the first one is where we have any national relative and the extended family members, and they were either residing outside the UK, so they were members of the same household, or the extended family member was dependent financially on the e-national. And most importantly, they would like to continue with the same arrangement. Here is the picture. So they either resided together or they were financially, they can prove the financial dependency, and when they're in the UK, they would like to continue with the same arrangements. So how can you prove this? By simply stating in your cover letter that upon your arrival in the UK, you either intend to live together with the EU national sponsor or they intend to support you. And you also need to provide evidence to confirm that they are in the position to provide you with this support. So they either have enough space in their house, so you need to provide them with the rent agreements to confirm how many people, how many bedrooms they have and how many people live there, or you need to provide them with the wage slips or some other proof to confirm that the e-national is working and they are in the position to support you financially. If you belong to this category, this is virtually what the Home Office will do. They will go through this, the definition of Regulation 8.2 of the 2016 regulations, and they will want to make sure that you meet every single requirement of that regulation. Alternatively, you may apply as a relative who needs, on a serious health grounds, strictly requires personal care of the e-national. According to the Home Office guidance, the serious health grounds need to be significantly beyond ordinary ill health. So, for example, the applicants must provide detailed medical evidence to prove this, and personal care must be provided on a day-to-day basis and relate to the physical or mental tasks and needs that the extended family member requires to function normally. And strictly, as you can see here, will be restrictively interpreted to emphasize the need for the personal care to be provided on a day-to-day basis. The next category is where the person can prove that they would meet the requirements of the immigration rules for indefinite leave to remain as a dependent relative of the EU national. Guys, these are complex rules with a very, very high threshold, and I've devoted the entire video explaining these particular rules, but very briefly, when a person applies as an adult dependent relative, they will need to meet the eligibility requirements, which consists of 3 components: the relationship requirements, the care need requirements, and the financial requirements. Normally, the relationship and the financial requirements is not a problem. This is the care needs element which is the problem. So here, the person will need to prove that they are not only severely ill, so ill that they cannot wash, dress, or cook, but they are unable, even with the practical financial help of the sponsor, to get this type of assistance in their country of origin, or it is so expensive that they cannot simply afford it. So as you can see, incredibly high threshold cases, and I've seen very rarely when someone would meet the requirements of Regulation 8.4. And the final one, Regulation 8.5, is all about partners in durable relationships. So here, they will need to prove normally, in accordance with the Home Office guidance, that the parties have resided together for at least 2 years in order to succeed in the application as partners in durable relationship. However, there are some exceptions where the Home Office will be prepared to exercise the discretion. For example, where we have the kids in the family. In these circumstances, the Home Office normally disregards the 2-year rule. Okay, so that is stage number 3 of the application process, and the last stage, stage number 4, is all about exploring the surrounding circumstances of the case. And here they look at the facts the decision will have on the EU national exercising their rights in the UK. So in other words, if they refuse the application, will this prevent the EU national from exercising their treaty rights in the UK? So will this make them leave the country and be reunited with their extended family member? And in their guidance, they've given 2 very helpful examples. So they said here whether the EU national will be deterred from exercising their treaty rights. And so the first example, they say here that the person, when they were financially dependent on the EU national back in their country of origin, it's highly likely that the refusal will force the EU national to leave the country and be reunited with their extended family members. However, they also give the second example where they say that if they refuse the application of the durable partner, then it is highly likely that it will affect the EU national and may force the EU national to leave the country. So they distinguish these 2 examples. But of course, they say that they will be exploring and analyzing the facts and the circumstances of every single case which they receive. And also, they will look at the conducive to the public goods factor. So just to remind you that unlike the direct relatives of the EU nationals, spouses, children under the age of 21, or dependent children over the age of 21, or dependent relatives, the extended family members unfortunately do not have any protection in relation to the decision taken on the grounds of public policy, public security, or public health. And all this means that the standard rules of the refusals on the general grounds will apply, and here they will look at the criminality issue. So they will want to make sure that the person is not subject to a deportation order, and if someone has got a conviction with imprisonment of more than 4 years, the application will be refused. If it is between 12 months and 4 years, then they will need to wait for at least 10 years before they can apply. And if the conviction was for less than 12 months, then the application will still be refused unless more than 5 years have passed since the end of this sentence. And also they will be checking if the person was excluded from the country. And here, if the person indicated that there was some criminality history in the past, they will want to take further evidence of their current criminal position. So this is normally done by the way of getting a police criminal record, or if they were in the UK, then they will make a police national computer check on them. Will the adverse immigration history affect the decision? Well, according to the Home Office guidance, normally no, this will not negatively affect the person. However, they will check on a case-to-case basis. Normally, this is to see if the criminality factor is triggered as well. And they do have a look at other factors. For example, when reaching their decision, they will see how the EU national in question integrated into the UK. So normally, when checking this, they will have a look at the length of the residency, family ties in the UK, whether the EU national is working and whether or not they have any property in the UK, and how the refusal may affect the EU national, and whether or not they will be forced to leave the country if the application is refused. And just to remind you that if the application is refused from 29th of March 2019, the extended family members were given a full right of appeal. So you'll have a right to appeal against their adverse decision. And this is it, my friends. This is all we wanted to discuss in this video. As you can see, the consideration process is a 4-stage process. The Home Office will first of all check the status of the EU national, and then they will have a look at the relationship and whether or not the extended family member qualifies, and then they will make a final check to see that the person's circumstances will not trigger the refusal on some other basis. Guys, this is the end of today's video. You're very welcome to explore this playlist further to see what else is there to check your rights. If you qualify, don't wait another second. Make an application as soon as possible because of the deadline, which is on 31st of December 2020. And if you would like to have more assistance with making your application, you're very welcome to visit the ukvisasuccess.com/EFM access, where you'll have more information about the online course which I've created for extended family members. I would like to invite you to visit this page, ukvisasuccess.com/more, where you'll find plenty of free immigration resources explaining various immigration rules. And I also invite you to subscribe to a new, very, very succinct and short newsletter where I'll be updating you on various changes in the world of UK immigration law, and also I will be sending various exclusive invitations to the members of ukvisasuccess.com community. You'll only be able to get these offers if you're subscribed to this newsletter. Have an amazing week, guys.